and the judges can introduce themselves.
Well, first of all, great to have you all here. Congratulations for getting this far. I know it's not an easy task, so congratulations and good to have you here. My name is Ali Khan. I am an attorney in Chicago, and as well as an alum of the program, I was representing the state of Illinois in 1998.
My name is Ben Glickman. I'm also an alumnus of the program. I represented California at the national finals in '95. In my day job, I work for the California Attorney General's office, and I'm also on the Center for Civic Education's board. So congratulations, and I look forward to our conversation.
Good afternoon. I'm Dan Taubman. I'm a senior judge on the Colorado Court of Appeals in Denver, Colorado. I am not an alumnus of the We the People program, but I've participated in it for many years. So welcome and congratulations.
Can you please introduce yourselves?
Yes, of course. Thank you, judges. We're very excited to be here. My name is Giovanni Munoz.
My name is Alejandro Perez.
My name is Kaylee Miranda.
My name is Jennifer Martinez, and like my colleague said, thank you so much for your time, and we are very excited to have this conversation with you.
Again, we're glad to have you here. So today we will be doing question 1. Okay, so here we go. I do not think the United States would come to an end if we lost our power to declare an act of Congress void. I do think the Union would be imperiled if we could not make that declaration as to the laws of the several states. What impact has judicial review had on federalism? Is judicial review a counter-majoritarian practice? Please support your position. What limits, if any, would you place on the practice of judicial review? You may begin.
Without a doubt, Justice Oliver Wendell Holmes' fight alongside the Union during the American Civil War molded his view on judicial review during his 29-year tenure. He understood that although state rights were crucial, a country divided in its fundamental laws could not survive. If no government body in the United States could interpret state laws and determine whether they violate our founding constitution, the nation's fate would be no different than that of the Articles of Confederation. Justice Holmes' quote exemplifies the necessity for the principles of judicial review and federalism to work hand in hand, not disjointedly. Federalism ensures that when the Supreme Court exercises its power of judicial review towards a state law, the court's decision does supersede. If it were not for the combined principles of judicial review and federalism, issues such as racial segregation and public schools across the nation would not be resolved by a case like Brown versus Board of Education.
In a government that is all about the representation of the people, the question has been asked for years. Do federal judges represent we, the people? The Constitution has given the people an indirect influence over who serves on our courts. This is through the leaders we directly elect, the presidents and senators nominating and confirming these judges. Article 3 has been seen as a necessary check to majoritism through judicial review. I personally do see judicial review as a counter-majoritarian practice, but I believe that this is integral to the idea of it, because there have been many times in our history where the will of the majority hasn't been right for the principles of freedom and liberty that America stands for. There are cases where laws and rulings have been overturned to fit those founding principles. Some of these cases include Brown v. Board of Education, Gideon v. Wainwright, and Loving v. Virginia.
The Founding Fathers intended for the judiciary to be the weakest branch. However, due to the contraction of their abilities, they have become nearly powerless. To put more restrictions on the judiciary would be catastrophic to our nation.
The judiciary plays a major role in the rights of the people, our state, and the nation as a whole. Yet it has been given little to no power. The power that they do have is very limited in itself. If there's an added limitation to judicial review, it would diminish before our eyes. Judicial review has helped shape our nation to ensure its prosperity, yet there are many limitations being placed on judicial review. For example, the legislative branch can simply pass a bill into legislation that may directly go against what a previous ruling from the judiciary was. This could be seen in 1984 with Grove City College versus Bell, where the courts had ruled that since the university did not receive direct grants from the federal government, it did not need to comply with Title IX. Following this decision, Congress passed an act that would expand Title IX to cover students receiving federal grants as well, therefore causing the university to follow Title IX due to students needing financial assistance.
The process of judicial review has had limitations implemented over the years. Some of the other limits currently placed on judicial review include lack of officers to implement their decisions and not being able to choose the cases that come to them. With these limitations, the judiciary has no power over the cases they decide on. They cannot enforce the decisions, and they cannot ensure that these decisions will last. To add any more limitations to judicial review would be to dissolve it. The court's legitimacy arises from the source of its authority, which is of course the Constitution, and is best preserved by adhering to the decision methods that neither expand nor contract, but legitimize the power of judicial review. Diane S. Sykes.
Judicial review has been a part of our democracy in this constitutional government for over 200 years. Without the protection of judicial review, it will manifest itself into judicial restraint. Those restraints will be felt in our nation for years to come. Thank you.
Thank you, guys. Obviously, you're concerned about the diminishing power of the court, is what I gather from your presentation. So let me ask you in relation to that, do you think there should be term limits placed on Supreme Court justices? Why or why not?
I believe that term limits should not be placed on Supreme Court justices. If we go based on what the founders intended, the reason why this was not the case is specifically to prevent the politicizing of the court. If term limits are in place, then Supreme Court justices may be pressured to make certain decisions simply before their term ends, because they no longer have to serve for the rest of their tenure.
Add on to what my colleague was saying, once you put term limits on Supreme Court justices, it brings around the issue, how long is that term going to be? Is it going to be 2 years, 4 years, 6 years? Either way, it'll either come during a presidential election or a midterm election. And then at that point, you're going to get our candidates going to tell people to vote for a certain person. And that adds way more to the politicization of it, which further proves my colleague's point of term limits adding the political aspect that the legislative branch or the president or the executive branch has to the courts.
But don't we already have the nomination of Supreme Court justices being an issue in the presidential race? I mean, you've seen the last two elections where, you know, both parties have talked about the importance of the presidential election in relation to the naming of Supreme Court justices.
Yes, we have seen a lot of politicization in the courts recently, and it wasn't just with the confirmation of Justice Amy Coney Barrett, but we also have seen it recently with a motion passing in the House to try to pack the court with 4 more justices. And I'm in agreement with my colleagues that I don't believe that there should be term limits on Supreme Court justices, because this just adds further politicization. We don't want the Supreme Court being a political body. We want the Supreme Court to be a fair and just body of our government that addresses the issues in our country fairly.
To add on to what my colleague was saying.
Actually, I wanted to follow up on what was just said. So I guess my question is the Supreme Court a non-political body, and has it ever been a non-political body? I mean, I realize that's the ideal, but is it the actuality?
The founding fathers had intended for the Supreme Court to not be a political body. However, with the evolution of time, I do personally believe that it has become a political body, essentially because it is very difficult for judges to put aside political beliefs. It's human nature almost to have your own opinion on things. Therefore, it's already an issue in our Supreme Court that there may be political beliefs being implemented in these really important landmark cases. And I think that is an issue we need to resolve immediately.
On top of that,
Sorry.
I apologize.
Everybody has these underlying biases that they may not even notice that they're implementing in their decisions. But it's not just the biases from the Supreme Court justices themselves or the court. It is also the climate that we live in, the very politicized climate of our culture that brings people rallying around the court to protest a certain decision that might be taking place that day, which further just shows that people think that the Supreme Court is political, and maybe it is, but it is also the climate that we live in.
And specifically relating to that political climate, we know that James Madison in Federalist 10 specifically argued that the Constitution itself was the best way to combat the politicization of just the government, as he argued that political factions at the end of the day were inevitable. However, he did argue that because the Constitution allowed for the political parties to develop their own opinions separately and be heard, that we could basically remedy the issue by allowing the political parties to actually have a voice and the people. So the Supreme Court, although it has become more political, in a sense, it may also be more demonstrative of how people are nowadays.
In following up on our discussion about whether the Supreme Court justices are political, do you think that they decide cases based on their political views or based upon different judicial philosophies?
Well, there could be arguments for both. I mean, most recently we saw former President Donald Trump trying to take and other Republicans trying to take multiple cases in terms of election fraud to the Supreme Court. And you had what some people would call conservative justices turn away the case and not wanting to hear it because they believe that it wasn't an issue that they should hear. Now, there are other cases where judges do adhere to their political biases, but I would like to believe that they more often than not look at it fairly and ignore these biases.
I would say it's a very thin line that is used, since it's almost human nature, the political beliefs and what you believe, especially when you are interpreting the Constitution. We don't know what the founding fathers exactly meant by every single word that was written in the Constitution, which is why we have our Supreme Court justices interpreting the Constitution. In that interpretation, there could be things lost in translation due to the fact that those Supreme Court justices are interpreting what those words mean to them specifically, not what the founding fathers meant, because we don't know per se exactly what they meant.
And adding on to what my colleague was saying, we mentioned this in our speech, talking about any limitations we would add to judicial review and the courts. The reason why we chose to say that we wouldn't is because of the inherent weakness that the court already has. You know, they can't implement their own decisions, and the legislative branch can make an amendment to overturn one of their decisions, and they can be impeached. So all of these things that already limit judicial review in the judicial branch, it's almost as if the founding fathers knew what they were doing by making the term limits non-existent. You know, in the Federalist Papers, Alexander Hamilton talked about how the judiciary should be more of the weaker branch. You know, the legislative is more of the stronger when it comes to passing legislation, but the judicial branch also has an effect on our legislation as well, but it is definitely the weaker of the two.
Okay. One thing, you know, and I think you mentioned a minute ago about former President Trump trying to bring some election fraud cases and the court turning them away because the court decided they didn't want to hear it. It wasn't worthy of being heard, so forth. Great. I believe, and correct me if I'm wrong, in your presentation, you mentioned the court does not have much choice in the cases they hear. Can you reconcile those two, or just kind of clarify what you mean?
So with that statement, what we meant is that, you know, the cases come up to the court and they do have a wide variety of cases that come to them, and they do have a limited amount that they could hear every year. But the cases that come to them come from the lower courts up. So they don't get a decision on what happens in the lower courts. They only see it when it already comes up to them. So if somebody doesn't decide to take it to an appellate court, then they can't have a decision on that case.
Thank you so much. And now the judges will have some feedback for you.
First of all, again, great job, guys. I know having been on the other side, it's not always the easiest thing. So great job, and congratulations for being here. You know, I liked your presentation. You guys spoke really well. I like the fact everyone participated. And we asked you some questions and we really drilled down. And I don't know if I agree with everything you said, but I liked your conviction in defending what you were saying, of thinking on the fly and being able to essentially, as I like to say, not panic under pressure and maintain your composure and answer the question. So great job on that front.
I thought you did a nice job. I liked your beginning approach of comparing Oliver Wendell Holmes' service in the Civil War to his views towards judicial review. I thought that was creative and logical, and so I appreciated that. I appreciate your mention of the checks that have been made through judicial review in cases like Brown versus the Board of Education, Loving v. Virginia, and Gideon v. Wainwright. And so those are good cases. I don't think you mentioned Marbury v. Madison, which is like a basic case on the principle of judicial review that you might have mentioned. And in answering our questions, you referred to a Federalist paper by Hamilton. I think you were referring to Federalist number 78. So you might have mentioned Federalist 78 by name or number, but I think you were definitely aware of it. And I thought that the example you gave when I was asking about whether judges act based on their political views or their judicial philosophies, the example of the Supreme Court deciding not to hear certain cases involving President Trump and some Supreme Court justices who were considered to be conservative, not wanting to hear those cases. There are some other examples that you might have mentioned. Like Earl Warren was appointed as a Supreme Court justice, and President Eisenhower thought he was going to be a conservative justice, but he wound up being a more liberal justice because once he decided to look at each case, he decided to look at the cases based upon how he thought they should be decided rather than on what maybe have been his political views before. And there are other examples of that too, such as Justice Stevens and Justice Satur, to name two. But your answer was a good one, and I think you showed a good overall understanding of all parts of the question. So I commend you for your presentation today.
Yeah, I would echo pretty much all of that. I didn't know that Justice Holmes served in the Civil War, so that was a new piece of information for me today, which I appreciate. I liked the sentiment that judicial review needs to kind of trump state law, otherwise issues like racial segregation could never be resolved statewide. I kind of like that concept, which you then transitioned right into the counter-majoritarian part of the question, where you said, yes, it's counter-majoritarian, but it has to be. That's a feature, not a bug, and it's integral to protect freedom and liberty. I like that discussion. I thought that was the strongest piece of the prepared remarks. I was a little, I guess I don't fully understand the thesis that the court, I think at one point you said the court was virtually powerless. And I don't know how we can square that with the amount of attention the court gets, right? If the court is virtually powerless, why is it such a focus during presidential elections? Why is it so controversial? Why do people care so much if it's powerless? And so I would have liked maybe to hear a bit more about why you think it's powerless, beyond the fact that it can't enforce its decisions, which is obviously true. But nonetheless, I think most would say it wields tremendous power, because its decisions bind the nation, federal and state alike. But I thought it was an interesting and engaging conversation. I'm just looking at my notes here. Yeah, I don't think I have much more to add. I thought you guys did a nice job overall. Congratulations.
Thank you.
Thank you so much for your time.